Welcome to Knowledgeable Aging. I'm your host, Jason Kotar. Join us today to talk about Revocable Living Trust is Lindsey Sarowitz. Lindsey has been with Handler Levine since 2013. She is an associate with the firm and regularly represents individuals, including federal government employees, in preparing their estate plans consisting of wills, trusts, powers of attorney, healthcare directives, and other estate planning documents. She also represents Estates and Trustees in regard to decedents issues, helping guide families through probate and trust administration following the loss of a loved one. Lindsey is a member of the bar in Maryland, Virginia, in the District of Columbia, and practices regularly in all jurisdictions. How are you doing today, Lindsey?
I'm good. Thank you so much for having me again.
Absolutely. This is our 6th webinar. My goodness, time flies.
Yes, it sure does.
All righty. So before we get started, for those that are joining us for the live webinar, there's a control panel on your right-hand side. If you have any questions, type your questions in. Time permitting, we will do everything in our power to get your questions answered. All right, Lindsey, so let's get started. So once again, this is our 6th webinar. Our last webinar, we finished up our series on probate. So I'm hoping you can give us a quick refresh before we get started on revocable living trusts.
I'm glad you said quick because I do teach a 4-hour class on probate. So
I know you do.
Today. So yes, so last time we talked a little bit about probate, and just a quick refresh. Probate is basically the court supervised process which identifies what probate assets a decedent held at death and oversees distribution of those assets, whether that's through the last will and testament if they had one, or through the state's laws, which would be called intestacy laws. Intestacy is dying without a will. So probate assets, meaning assets that go through probate, are just assets that are titled in the decedent's name alone, so not held jointly with somebody else, and without a beneficiary designation. So here we're typically not talking about life insurance or about retirement. Those will pass by beneficiary designation unless there wasn't one, right? Or unless someone directed it to the decedent's estate. So, you know, the probate process, it varies from jurisdiction to jurisdiction, but it's always going to be, there's some sort of process, some sort of court oversight. It's going to begin with a petition for probate is what it's typically called, and filing a decedent's last will and testament, again, if there is any. There's some sort of proof of death that's required, right? The court needs to know that the person has passed away, whether that's an official death certificate or what have you. And then basic information about the people, right? Who's interested in the estate, meaning who would inherit from the decedent if there was no will. Those people are called heirs. And who will inherit from the decedent under the will, again, if applicable, those are called legatees. So again, the probate process definitely varies from jurisdiction to jurisdiction, but there are themes throughout, right? There's some sort of court oversight, there's some sort of valuation of the assets, eventual distribution to the heirs. And I think one important aspect of probate that a lot of my clients don't understand is when you go through probate, it's not like nothing can happen until the probate is completed, right? Sometimes people think that, like, oh, the probate's happening, so we can't do anything until it's done. Well, that's not true, right? The probate process is the process of doing those things, selling the real estate, right? Selling other assets and distributing them to the estate account, things like that. And then at the end is when they're distributed out to the people, right? The people who are inheriting. So that's just like a really short snippet of kind of the overview of probate, I'd say.
All righty. Well, let's get going. What is a revocable living trust?
Sure. So a revocable living trust is an entity, essentially. So you're creating an entity during your lifetime. So basically, you do the paperwork, right? You draft it, you sign it and everything at the most likely attorney's office to create this revocable living trust. So I think of it as kind of a box. So we build the box for you, box being the revocable living trust. That is that separate entity, which, and I'll tell you what the benefits of it are shortly. After it's created, right, after we build that box, assets need to be transferred into it. The reason we do this, one of the main reasons we do this, I should say, is because when you transfer assets out of your name, right? Remember I said the revocable, sorry, the assets are going to be probate assets. Well, if we transfer them out of the decedent's name alone before they are a decedent, of course, and put them into this separate entity, they are no longer in your name, right? So the Lindsey Sarowitz revocable living trust, right? Let's say I create that. Well, I then transfer my bank account into it, my brokerage account into it, my real estate into it, and so on and so forth. And now Lindsey Sarowitz doesn't own anything in her name alone, but rather it's all in the trust name. So you see, that's kind of the workaround. That's how you get it out of your name alone, and therefore out of probate. So it's not like this magical process where you go to an attorney's office, they draft the documents, and then bam, you're done, no probate, right? The attorney will transfer in certain assets like your house, right? We can do deeds for people, but we can't go to the bank for you. We can't go to the brokerage houses for you and transfer all that in. So there is additional work that needs to be done on the client's or the grantor's end, right? So the trust is going to be created by the grantor, right? You would be called the grantor. And then typically you would also be the trustee. The person creating the trust would be the grantor, as well as the initial trustee, meaning the person who administers the trust. You're also the person who benefits from the trust, right? So during your lifetime, this trust is set up for your benefit, maybe for your spouses if applicable. But one thing that a lot of clients, or some clients I should say, get a little bit worried about is, are they giving up access or control? And the answer is, absent some sort of other, right, way that it's done. If someone does it a different way, maybe, but this way, right, the typical way of creating a revocable living trust, you're not giving up access, you're not giving up control, you're still the person who benefits from it, and you still sign the checks, and you still, you know, use your own social security number and everything like that. Does that make sense?
It does.
Hopefully.
We've got a long way to go, so no worries right now. So question, what does funding your trust mean?
Yeah, so funding is basically that process of transferring those assets in. So like I said, the attorney can help you and transfer in your real estate, but then they'll give you, or they should give you, what's called funding instructions, right? So telling you how to transfer in those other assets. So if you have a safe deposit box, right, how do I put that in my trust? If I have oil or mineral interests, right, how would I put that in my trust? My vehicles, should I put those in my trust? You know, all those sorts of things. There's no one size fits all, and I think we all know that in whatever industry we're in, right? So the different individual will have different assets, and they may look like other people's too, but basically you need to know, based on your own assets, how to transfer them into the trust, and that is the funding process.
I'm probably getting ahead of us here, Lindsey, but is there a limit to what can go in this entity or this trust?
Oh, that's a really good question. So it depends. That's such a lawyer answer, isn't it? So limit, no, as far as like asset limit, anything like that. But some assets can't be transferred in. I can give you an example of something that I've dealt with. in the past, in the recent past. So sometimes one of the reasons we will suggest a revocable living trust-based plan for a client is if they have difficult to probate assets. So a difficult to probate asset might be some asset that is going to require a expensive or hard to find appraiser. So maybe an antique collection, you know, a very, you know, big antique. I'm not talking about like an antique rug or whatever, piece of furniture, or a lot of times business interests. So if somebody owns a business and then they pass away without some sort of mechanism to avoid it going through probate, it will go through probate. So everything that passes through probate needs to be valued or appraised. So some things, and I think we might have touched on this last time, are very easy to value, such as vehicles. We just pull the Kelley Blue Book value. It takes 5 minutes or less, right? Stocks, we go on the historical stock prices online and pull that. But businesses typically require a formal valuation, which can sometimes be very expensive. So depending on the business and what the, for instance, operating agreement, for example, would say, there are sometimes restrictions on transfer into a revocable living trust. That's not super common. In my mind, a lot of times people have restrictions on transferring their shares, for example, when, like, if someone passes away, they might not want the other partners or other members of the LLC to have to go into business with that person's spouse or that person's children, right? So they don't want them to be able, or even before they pass away, so they don't want them to be able to transfer their shares to somebody else, and now these other members who originally went into the business with the first person have to be in business with the second. So usually the revocable living trust is not one of those restrictions on transfer, but sometimes it is. And I just recently encountered that with a client that has a large business, and unfortunately at this point we can't transfer his shares into the trust.
Can you clarify for us, before we move on, an example of typical assets that would be transferred?
Yes, definitely. So some typical assets, definitely your real estate, right? So any state that you own real estate in, there's going to be a probate in. So if you own real estate in multiple jurisdictions, now there's going to be multiple probates. So now maybe it makes even more sense to transfer your assets, including but not limited to that real estate, into a trust. So bank accounts, brokerage accounts, you know, so a lot of times people don't want to go to the DMV to transfer their cars into the trust, and I don't blame them. So depending on the type of car, the age of the car, you know, the jurisdiction, most jurisdictions have some sort of small probate process. So a lot of times people might choose to leave their vehicle out of the trust and maybe their small working checking account, right? And what do I mean by small? That's a very relative thing. I don't know, $10,000, right? To some people, small is $300,000. That's not what I'm talking about. So in addition to land, you know, it's that brokerage account, that cash account, things like that. But I'm not talking about retirement, right? You're always going to own your own retirement account.
Okay. How does someone know, Lindsey, if a revocable trust is right for them?
Sure. So we look to a lot of factors. Like I said, if you own real estate in multiple jurisdictions, maybe that is, you know, a reason enough, because Maryland, for example, and I probably have told you this before, Maryland is not a particularly difficult to probate state. You know, our probate processes here in Maryland are pretty straightforward. So if someone owns, you know, just regular assets here in Maryland, they might choose to do the simpler, maybe less expensive will-based plan. But now, let's say that person owns real estate not just in Maryland, but in Florida as well. Well, now they're going to have a probate in Maryland and a probate in Florida. Maybe they just want to avoid that. So, so having the trust and transferring both assets in, or both pieces of property in, will avoid those properties going through probate Maryland and Florida. So the more states you touch, and by touch I mean own real estate in, the more a revocable living trust is going to make sense for you. I also touched on the difficult to value assets, right? So if you have difficult to value assets, maybe then a revocable living trust is something that you might want to explore. As people age, sometimes a revocable living trust is more attractive to them, because for incapacity planning, having a trust-based plan is somewhat easier, because remember how I said we're transferring the assets in, right? So if we transfer the assets in, your brokerage company already has a copy of the trust. They already have they've already sent it to their legal department for review and approval before they transfer it in, and they know who's in charge if you become incapacitated, right, as the successor trustee. So now when your backup person, the successor trustee, needs to step in and handle that account, whatever handle may be at the time, they can just kind of go in and do that, rather than if you didn't have a trust, typically they would have to step in using a power of attorney. And unless that power of attorney is effective immediately, they would need to prove that you are incapacitated, and therefore they need to step in and help you. So having a trust for incapacity purposes definitely makes things easier as well.
A follow-up question on that, Lindsey. So is where an individual is domiciled or where they live, is that where the estate or trust is set up for that, for the laws? Because you were mentioning like if they have property in Maryland and Florida. So if they're living in Maryland, is that where the trust is set up? So then is that what I understand?
Yeah, yes. So exactly. So where they are domiciled, and a simple definition of domicile would be like where they reside and intend to remain, right? So usually that's a pretty clear standard, but for people who split their time, you know, we look to where are they registered to vote? What does their driver's license say? You know, things like that. So yes, that is both where the trust would be set up, and also if they were to pass away and there was a probate, where the probate would occur.
Gotcha. That clarifies it. Thank you.
Sure.
So are there any disadvantages to this revocable living trust?
Yes. So I would say the disadvantages, I would say, are the difficulty and the cost of setting it up. So I should have actually mentioned when you said, you know, how do we know if, you know, what are things that we look to determine whether a revocable living trust is right for you? And one of those is truly your goals. And I think that that's the most important one. So if your number one goal is to make things easier on the back end when you pass away or when you become incapacitated, a trust-based plan is going to do that for you. But it's harder and more expensive on the front end. So for some people, they've been putting off estate planning for a very long time, right? It's a very common thing that I hear, hey, I heard you in a seminar 3 years ago. I've kept your card ever since. Or more than that, you know, hey, I heard one of the partners of the firm do a seminar 10 years ago, and I've been meaning to reach out ever since, right? It's not something that people really want to talk about or think about, generally speaking. So for those people, if their number one goal is to get something done, right? They've been putting it off so long, they just need to get it down. they can barely stand the thought of even signing a will, right? Then maybe a will-based plan is right for them, because like I said, one of the disadvantages is that it's more work on the front end, not to mention it's a little more expensive, right, to create a trust, because it's more difficult for the attorney to actually create. So there's that kind of balance, or looking at the client's goals, because for instance, if you are not married, you have no children, you're leaving all your assets to charity, right? You might care a little bit less if the charities need to jump through a few hoops or wait a little while to get their money, right? Whereas someone who's married, has kids, whatever, they might want to make it as easy as possible for the people they leave behind, even if it's a little more difficult on the front end. I think that that sometimes people get confused about why this is going to be helpful, because sometimes people, you know, I've had people say, well, my mom had a trust and we still had it go through probate, right? So one important thing to keep in mind is that, like I said before, having a trust is not some magical thing. You don't go to an attorney and create the trust and now suddenly everything's good, nothing goes through probate, right? So you have to take those additional steps of funding the trust, like we said. But even if you fully fund your trust, right? You transfer all your real estate in, you transfer all your otherwise probate assets in, oftentimes there will still be some sort of probate. So for example, depending on what time of the year you die, right? You might have a tax refund and it might come in real soon or many months later. You might have a Verizon refund or a refund from your health insurance company, or things like that, that just, no matter how well we plan, those things happen. And then those checks, for instance, they're going to come in the name of the individual. So now something coming in the name of the individual instead of in the name of the trust, right, is going to pass through probate. But it's important to remember that the small estate procedure is typically much simpler. In Maryland, if the decedent owns $50,000 or less in their individual name, or if everything's being left to the spouse and they own $100,000 or less, it will qualify for a small estate proceeding, which literally in the Maryland Register of Wills, that's our probate court, will be opened and closed the same day. There are no follow-up filings, and you see, that sounds pretty easy, right? And it is. So that's one thing to keep in mind. And then another thing that I really try to drive home to my clients when we create a trust for them is, do not rely on the pour over will. So let me tell you what that is, because I know there's a lot of questions on that. So when you do a trust, you're also going to sign a will. The will is going to say certain things like what you want to happen, whether you want to be buried or cremated, how taxes are handled, and various other things like that. If you have minor children, who the guardians of your minor children will be. And then it's going to basically say, anything that I forgot to put into my trust will go to my trust. People misinterpret this sometimes, and if it's not discussed, I can see how. The pour over will works to funnel things into the trust, again, that you forgot or didn't put in your trust. But it shouldn't be relied upon, and the reason I say that is because the assets are going to go through probate and then into your trust. So if someone creates a revocable living trust and does not fund it, right, they create it, they have the piece of paper, but it's an empty box, right? They didn't transfer things into the box. then what's going to happen is their assets are going to be still probate assets, right? They're still titled in their name alone because they didn't title them into the trust. So now they're going to go through the probate court. The will says, okay, anything that goes under this will is transferred to my trust. So at the end of the probate, it's transferred into a trust. And now we have a trust administration, right? The main point, or one of the main points of having a trust, is to avoid that step of probate.
Yep.
And so that way you're creating an extra step by having a trust, whereas if you just had a regular will that said where your assets went, right, then at the end of the probate your assets go to whatever people you say in the will rather than into that trust. So I cannot stress the point enough that it is essential to actually transfer your assets in during your lifetime.
If you have a joint account, can joint accounts go into a trust?
That's an excellent question. So if you have a joint account, let's say you own your brokerage account with your spouse, right? And it's so jointly with rights of survivorship, right? Without a trust, and I know this wasn't the question, it's going to pass at the first spouse's death to the surviving spouse. So that would be a non-probate asset. And then at the second spouse's death, it would go through probate. Back to the question. That kind of asset, yes, can be transferred into a revocable living trust. Now, whether the spouses, in my example, have one revocable living trust together and they're both grantors and they're both trustees, or whether they have two separate revocable living trusts, they would usually be trustees on both, but then only one is the grantor for each. That depends. That depends on the situation. That depends on the jurisdiction. But the answer is absolutely, you can transfer those joint accounts into either one joint revocable living trust, or if there's two, typically it would be the two trusts would hold the account as tenants in common rather than as joint tenants.
Is that based off of which state, right? Like tenants in common, is that a Maryland, or is that the same thing in Florida? Or, I mean, a tenants in common, I know that from real estate, but is that a common, whatever you want to call it, for Maryland as it is for Utah?
Yeah, a form of ownership, absolutely.
Same form of ownership, thank you.
Yes.
Okay.
Yes, so trusts never die. So generally speaking, you wouldn't name two trusts joint with rights of survivorship. When you name two trusts, it would usually be as tenants in common, but it's the exact same thing for brokerage accounts as it is for real estate. Yes.
Once this entity is formed or created, do you file taxes on a trust every year?
Good question. I should have mentioned that. Thank you. So taxes are not going to change. It's still going to be, it's a see-through trust, and you're still going to use your social security number, you being the grantor, whoever created the trust. Same social security number, taxes are going to be the same, everything like that. Once you pass away, that trust becomes irrevocable. And now, yes, you may have to file a separate tax return on that trust after you're gone, but not during your lifetime.
Gotcha. We had a question here. I'm not sure this question is fully formed, but I'll ask it, and if there isn't, we'll see if we can get the individual to clarify. It says, what if the joint accounts are siblings?
Oh, that was probably the person. I assumed it was a spouse. So if the joint account is with siblings, I mean, the answer is still yes, it can be transferred into a trust, but you're going to sever that joint ownership, right? And you know, from real estate, the benefit of owning accounts or real estate jointly with rights of survivorship is when one joint owner dies, it just passes to the other. Now, if you sever that joint ownership and essentially one sibling creates a revocable living trust and the other doesn't, then your revocable living trust would have to own it, I suppose, as tenants in common with the individual. So I guess I would say in that situation that it's very important to consider why you have a joint account, right? So I see sometimes people naming people as joint account owners because they just want to make things easier. When they pass away, they figure, okay, now my sibling can access it, and it'll be much easier, and so on and so forth. But then they don't really, I'm not saying that person who asked the question did this, but I'm just saying some people don't think it through as far as, oh wait, now I'm making my asset subject to my siblings' potential creditors. They can come from my account while I'm alive because my sibling has, you know, some creditors out there, or wait, that person, that joint owner, can withdraw all or most of my money at any point in time. Or another one is, hang on, that sibling is going to get the entire account when I pass away. It's not going to be split according to my will to maybe all of my siblings, right? So a lot of times, I would just say, not a lot of times, I would always say to consider why you're planning to name someone as a joint owner prior to doing so. A great alternative to doing that is creating a trust and making the sibling a backup trustee, or even potentially a co-trustee. Because if that account is in your trust, right, and then your sibling is a co-trustee, for instance, they can access it, they can manage it, but it's not for their benefit, right? They can do things, but it doesn't just go to them at your passing. Hopefully that's helpful for that person.
Yeah. I know we had talked in previous webinars that your will, you don't just make your will and then just let it sit. You should review it. Is that the same thing with your revocable living trust?
Yes, it's the same thing with all of your estate plan. So
Okay.
your estate planning documents, as I'm sure you recall, are your power of attorney, your healthcare directive, your last will and testament, your revocable living trust if applicable, and then quite honestly, your beneficiary designation. So retirement, life insurance, all that. Those things should be thought about, we say at this firm, every 2 to 3 years, right? If changes happen in your life, it's important to reach out to the attorney who helped you and discuss those changes and whether they impact your estate planning and whether an update is necessary. If changes haven't occurred in your life, I would say sit down with your attorney every 5 years or so, because you know what changes happen in your life, and we, or the attorneys, know what changes happen in the law. Unless we sit down together, we don't see the other side of it. So the trust is absolutely something that should be thought about, and it should be continuously thought about as you obtain more assets, right? So if you open up a new account, well, if you open it in your individual name because you forgot that it should have been opened in the trust name that you created 5 years ago, well, now that is going to be a probate asset, and that isn't going to go through the trust. So it should be kind of back of your mind. I don't want people to obsess too much, but it should definitely be something that's thought about, and certainly the funding process can and will travel with you throughout your lifetime, right? You sell your piece of real estate that you're living in now, you buy a new home, well, now you buy it in the name of your trust, right? So that's kind of how that works.
Very good, Lindsay. Very, very good. So how can people find you?
Sure. So we are physically located here in Bethesda, Maryland. A good way to find us, to reach out to us, is by going on our website, which is www.handlerlevine.com, HANDLERLEVINE.com. And then our phone number is 301-961-6464.
As far as knowledgeable aging, you can go on to our website, knowledgeableaging.com. You can see all of our upcoming and archived webinars. Go to YouTube, type in knowledgeable aging. We encourage you to subscribe. That way you can see when we add to YouTube, which is usually 4 to 5 times per month. If podcasts are your thing, you can find us on Apple Tunes, Spotify, etc. Till next time, I'm your host, Jason Kotar. This is Knowledgeable Aging.